sometimes there are conversations that are so deeply ingrained in the never-ending quest of human life that they continue for our lifetimes, they continue for the lifetimes of humanity with imperfect answers. There is a reason that philosophy written 3,000 years ago, whether in India or abroad, is still relevant to reading today, because the trials and challenges and tribulations we face affects us today as it has in the past. If you read the Artha Shastra, if you read the works of the Buddha, if you read the works of Plato and Socrates, they're relevant. We are looking at self-discovery. We are looking at an importance of how the world will change. We're looking to identify ourselves, understand ourselves, who we are, what is good, what is bad. So the Ramayana could be 4,000-5,000 years old, we don't know. Mahabharata could be equally old. But the lessons of good and evil remain. So those are conversations we should embrace for our lifetimes. There are other matters, many other matters, in which chapters need to be closed. In jurisprudence, some of these vexatious matters like divorces, property disputes, they only create ruin, khandars, barbadi. Keep going on and on and on until families are destroyed, until the property itself which you disputed has collapsed. So those are matters which are best resolved quickly to everybody's benefit, and you move on. Ladies and gentlemen, we've had these kind of matters burning like sores on India for a long period of time. Ayodhya was one of them, year after year, decade after decade, burning like a sore. Now let me pose you a simple premise. If you go to America today and you find out that the descendants of George Washington are still there, but George Washington was a slave owner. Now these descendants are not slave owners. It's not their fault that their ancestor's ancestor was a slave owner. It is both in the benefit of the descendants of George Washington and in the benefit of the descendants of whom he himself had enslaved that monuments to those who suffered are put up, that the people whose ancestors were aggrieved find truth and reconciliation. It is to the benefit of both. So if Aurangzeb came, if Ghori came, if Ghazni came and they destroyed the temples, it wasn't done by modern Indian Muslims. It is in the benefit of modern Indian Muslims if this whole is corrected. It is the benefit of Hindus if this whole is corrected. What you are seeing in Ayodhya is an example of that. So now let's come to the subject at hand. Do we want the issue of Kashmir as a domestic conversation? Not about POK. What is Kashmir? Why is it special, not special, constitutional, legal, 52, 54, 48, Sheikh Abdullah, Hari Singh? Do we want this as a forever conversation? Like Plato and Socrates, forever, forever? Or do we want to end it and move on to next? It's a fundamental question. Now, it's been near 4 years since Article 370 was abrogated. Now, let's face it, you and I have a very little understanding what that actually means. Okay? So, for which we have to go back to repeat conversations. So, there is a Nehru, there is a Sheikh Abdullah, there is a Liaquat in Pakistan. Okay? They have invaded. Maharaja Hari Singh wakes up after having dawdled and done what nonsense, okay, that he is in trouble. He's going to be captured. It's a humiliation. So he calls up the Indians. He signs the instrument of accession. Then you have General Karyappa who comes in, General Thimayya who come in, okay. Then they turn the tide. They go back. Some of them, like Rajinder Singh, die to the last man, saving Kashmir. Then the British backstab and they hand over Gilgit-Baltistan with Major Brown. And all these things happen. Somewhere in this, the war stops. And a deal is made, and it's called the Agreement of Delhi, principally between Nehru and the grandfather Abdullah. And this mysterious deal starts affecting India's constitutional, where an article is inserted called Article 370, which allows the J&K Assembly to decide how much of the institution of the Indian Constitution applies to the state. So the J&K Assembly will decide whether the Indian Constitution, in what level it applies to the state of J&K. This is put in a special section called Part 21, which is temporary, transitional and special provisions, which is why it's called special status. It empowers the state constituent assembly to decide what parts of the Indian Constitution will apply to it and will not. Those recommendations are sent to the president, and the president then gives a presidential order, as was done in 52, then 54 and subsequently after. But the 54 one is which we consider the most, because Article then 35A, which is in an addendum to the Constitution, gets inserted as one of the exceptions which 370 allows you. The J&K Constituent Assembly dissolves itself, but because it did not use its right to dissolve Article 370 with it, we for some reason think it is a permanent part of now India's constitution. This gets challenged in 2019, which, remember, through a presidential order, the text and therefore the meaning of Article 370 is changed. The presidential order, which was 35A, is changed because that was not constitutional. And a bill is indeed brought in, but the bill is a reorganizing, shutting down the senior house, creating the union territory and creating the state of Jammu and Kashmir, as well as ensuring that hundreds of Indians' laws are now applicable to this to the state. This is what happened. Now, this is in dispute for various reasons. So now let's open up this conversation. Joining us on the broadcast is Advocate Geeta Luthra, Dr. G.V. Rao is with us, Ajay Kumar is with us, and Nishant Rana joining us with us as well. While I'm waiting for Geeta ji, Dr. Rao, so here we are, okay. Now I'm not going to chew anything, okay. There is a technical legal argument that I don't know whether it's been resolved or gets resolved tomorrow. But in the overall picture of 370 and special status, how long should this continue, or should there be an underlining at some point of time?
Good evening, everybody. Good evening, Rishabh. You see, the point is that, firstly, yes, it's come to courts. 370 was abrogated. 35 was also watered down and is made ineffective. But we need to see this in the historical perspective a bit. You outlined some of it, but I'll give you only the most focused point. That is, at the time when the 540 other princely states were given the option of joining India, at the time when we got independence, 3 states, Junagadh, Hyderabad and Jammu and Kashmir, were hesitant for various reasons, including some religious, majority or whatever. So now Hyderabad and Junagadh joined in. Jammu and Kashmir was thinking, although it had a Hindu king, Raja Hari Singh, and it was a princely state which the British actually sold to his forefathers, and it was an independent state. And while he was twiddling his thumbs, the tribesmen from Northwest Frontier Province, which was governed by so-called Pakistan Dominion status, entered, and they were about to come to Jammu and Kashmir. Raja Hari Singh panicked, He wrote a letter which I have seen because I've been doing research and writing something on Kashmir. And he said, please come to my rescue.
Yeah, so the thing,
Then just listen to it.
yeah, so the reason I've already recapitulated as much as I can on the history, sir,
No,
is
no,
so
but
that I
please
don't have to
listen to
discuss
that.
it again. My question was different, sir. Do we need to move on, or do we need this constant discussion on Article 370 for the rest of our lives?
For 1 minute, just 1 minute. I won't take more than. Now, then what happened? He wrote, and Lord Mountbatten said, sign the instrument of accession if you want the Indian state to help you. And Raja Hari Singh signed the instrument. BP Menon traveled to Jammu. Raja Hari Singh left Srinagar and was in Jammu. He signed the instrument of accession, and that makes Jammu and Kashmir as of that day an Indian state. Literally speaking, except for the subject that you talked about, that is defense, foreign affairs, finance, etc. Now, having done that, this so-called this thing, there so much politics took place. It was invaders who entered the state. It was not given to Pakistan. They didn't choose to join Pakistan either, and for that matter, they chose to join India, and it becomes an Indian state. Slowly, gradually, it gets integrated into Indian state. We pay for the finances of lakhs of crores, something to the tune of 1 lakh crore between 2000 to 2016, 18, and in the last 3-4 years, another 1 lakh crore. We have been supporting the entire state of Jammu and Kashmir financially, as well as slowly, gradually, the Sadr-e Riyasat was removed, Prime Minister was removed, it became governor, it got integrated because there was no constituent assembly, and
Okay, Dr. Rao, with all due respect, I'm going to try again, sir. My question was, you and I have had these conversations before. We've been having them for years. In this country, we've been having it for decades. Is it over? Do we need to move on?
And there's a logic for it, not just to put it into it wrongfully, but fairly and justly in the hands of the court, just the way the investigation was done, just in other matters the court decides, and the court must decide.
Okay, all right. Let me get Dr. Ajay Kumar into this. Dr. Ajay Kumar, I know the history is complicated because the situation itself was complicated. I have to give due respect to the people who made judgment calls. Some of them may have made historical mistakes, but we have to understand the situation was different. India has just seen maybe millions of people die in a famine. We've just seen hundreds of thousands die in partition. Hyderabad, which is a massive state, is an open rebellion where the Razakars are striking. There are many reasons why we probably created this deal and Delhi agreement with grandfather Abdullah and Nehru, okay? And there are many reasons why this Jugadu system was put into place in terms of special status. But I'm sure that these reasons have been gone into in 2019 by the best legal experts of modern India. And they have concluded that by changing the language of 370 through a presidential order, by removing 356 with 35A, which anyway was a presidential order, and by moving a reorganization bill, we have covered the constitutional requirements. Now, this of course can be challenged in court, which it has been challenged in court. So, the question to you then, sir, is if the court finds merit in the challenge, is it conceivable that a reversal can be done at this stage?
You have a very pertinent question, and going by the 16th submission by the petitioner as well as from the Government of India side, now the D-Day is tomorrow when the 5 judges Constitution bench is going to pronounce the verdict in the court. So let's not comment anything on the judgment which is going to be pronounced by tomorrow. But yes, as far as my legal understanding of the situation, what has been done by Government of India is 100% constitutional. If you permit me, and I go by the argument of the petitioner, they are saying that their sovereignty was taken away. But let's be careful and not forget that sovereignty doesn't mean autonomy. In the name of sovereignty, the petitioners
No, in fact,
are asking for autonomy, which was never intended, which doesn't exist. Yes, you had your internal sovereignty under Article 370. That doesn't give you an autonomy which the petitioners are asking for. So tomorrow declare J&K an independent country. That they are asking for, which is not tenable, which was not tenable.
no.
Because when J&K surrendered its sovereignty by signing the accession treaty with India, it was also the end of the autonomy. See, government of
No, that's
India
not what they're asking for. So
19
let me then tell you exactly what's going on. Okay, the simple point of argument is that the abrogation of Article 370 is by technicality unlawful because it was the J&K Constituent Assembly that was empowered to either use the article or to have the article removed from the Indian Constitution. Because the J&K Constituent Assembly dissolved itself without removing it, therefore it should be considered a permanent part of India's Constitution. And if there is a body that can recommend the removal of 370, it is the inheritor of the J&K Constituent Assembly, therefore the J&K Assembly and not Parliament. This is where the argument resides. It's not about sovereignty and autonomy. Those are all arguments that stem from this basic fact. The question which I am trying to answer, which I've been asking everyone, is on what Hari Singh did, on what Major Brown did, on what Nehru did, on what Abdullah did, what happened in 48 and 52 and 54, how much longer does this require to be a point of vexatious conversation? In a modern India, can we stomach that a move has happened which potentially could be beneficiary to everyone? It has followed, I am assuming, legal advice. It has been challenged in court, which the court will now give a judgment and opinion on. We don't know what that is going to be. But after all of this, just like in the case of Ayodhya, we need to move on. We need to think about POK. We need to think of other things, development in Kashmir, and not be discussing Hari Singh for the rest of our lives like we did for most of mine. Let me get Nishant Rana on this. Nishant Rana, is that too much to hope for?
Yes, yes, please. So I understand what's the main issues and what the main question is. Your main question is are the people or the citizens or the democracy of Jammu Kashmir are ready to move on? Are they ready to break the old law? Are they ready to step into a new world? This is what you are asking. Am I right?
No. I asked, can we move on? Because I'm hoping that an extremely vexatious issue like Ayodhya, it is beneficial to both the Muslims of this country and the Hindus of this country to move on. Sometimes you need to move on. Some things forever you need to discuss. I spent 10 minutes at the beginning part of this conversation setting it up. Some things you need to move on from. Ugly divorces and property disputes in personal matters are something we should all aspire for moving on from. So should we move on as a country? The court will do what it has to do tomorrow in its own interpretation and its own wisdom. But as a country, do we need to move on from this debate on 370 and Nehru and Abdullah and 48 and 52 and 54?
Yes, as a country, now we need to move on, because as a country, there are now many big issues which are lined up and which are about to come, which the country has to face. We cannot, India is now a big developing country. Indians are not expected to live in the past or to have a debate on the things which are in the past. The matter of Article 370 is sub judice. The matter is pending before the Honorable Supreme Court. And tomorrow, whatever be the judgment, we all have to abide that judgment.
Okay.
But yes.
No, I don't know what the judgment is going to be. And
exactly.
And it does. And the judgment also then allows for recourse. The judgment can be.
Exactly.
So what are the options? Okay, what are the options? The judgment can agree with the petitioners. The judgment can disagree with the petitioners with caveats. The judgment can be to make recommendations but not change the status quo. It can be any of these things. Probably the latter two, we don't know. Okay, but as a country of having spent generations discussing 48 and 52 and then this resolution. I mean, think of the UN resolutions, okay? Every time you meet a Pakistani, he wants to talk about the UNSC resolutions of 48-49, of 1948-49, okay? Should we move on? So as India, we moved on, okay?
Yes.
We moved on. In Ayodhya, we are moving on. Now, on the question of 370 and its abrogation 4 years later, will we take 50, 60 years to move on? Or do we as a collective mindset think, listen, we have to develop Kashmir, we have to get these things done, the people will benefit from it, okay? The country will benefit from it. Then we have to look at POK. How do we get POK back? That has to be the next topic of agenda. We can't talk POK back because we're still trying to figure out what we're doing with JNK. It's laughable.
Exactly.
So let me get Janvi into this. Janvi, what is the lesson we have learned from Ayodhya, which was 500 years of a vexatious problem, which in a ruling of the court itself, the highest court in the land, after decades and decades, starting from the British era, court cases, we are coming to a conclusion which seems to be peaceable and everybody is moving on. There's a healing touch. There's truth and reconciliation going on. What's the lesson we've learned from there?
Thanks. So, as we have seen in the Ayodhya judgment, and that was also a decade-long litigation, and then subsequent appeals, and we finally got closure with the Honorable Supreme Court judgment, and now we have moved on. So, I feel the lesson here and the knowledge here that we are going to get is that once the Honorable Supreme Court gives a final judgment, we have to abide by it, we have to accept it, and we have to move on from it. So tomorrow, whatever the verdict may be, once it's out, we have to make peace with it and we have to move on. We have to focus on integrating, to my mind, the state of Jammu and Kashmir with India, with the country as a whole, with all the other states. We have to integrate the people, make them feel more a part of our country than they have probably perhaps felt over the last few decades. And to put an end to negativity, to enmity, to toxicity, and to sort of move the narrative in a positive direction, in a healing direction, like you said, and also with the future in mind.
Okay, is it tenable or is it possible, Dr. Rao, that the future lies in thinking about the future and not trying to figure out कि भी उसने जी नेहरू ने ऐसा कर दिया था जी, शेख अब्दुल्ला ऐसा था, फिर करियप्पा को किसने रोका और यूएन पे कौन पहुंच गया, ये क्यों कांड किया, वो क्यों कांड किया, इधर क्यों कांड किया, हमें पता है, वी नो things didn't go well.
Recording stopped.
Yeah, so things went well in Hyderabad because you took security measures and in a matter of days these aspirations of the Nizam and his Razakars were extinguished, chapter closed. The same applied to Goa, the same applied to Pondicherry, chapter closed. Now, at what point of time do you see we'll be able to close this chapter on कि जी उसमें जी उस स्पेशल ऑटोनॉमी कि उसको सदर रियासत नहीं, मेरा ये फ्लैग, मेरा वो, इन अ मॉडर्न कॉन्टेक्स्ट फॉर नॉर्मल पीपल इट्स ऑल दीज आर ludicrous things. It's one country, okay, we're all Indians, we have to develop the state, we want to travel there, boost tourism, and we have to think of POK.
You see, Rishabh, the matter is before court. When it comes to court, court will look at historical background, what are the legal documents that were signed, how did the constitution and the country react, what were the laws that were, now it has to be decided purely legalistically. I understand what you're saying. Your question is simply how long can we deal with it. But unfortunately, we've had issues and the government rightly abrogated Article 370 and the 35A. And therefore, you're right about that. In law, we have what is called statute of limitations. Because if something doesn't get, there is not sorted out, or there's a period of lapse for that, for everything, for property disputes, for check bouncing, etc. There's 3 years, 12 years, blah, blah, blah. So I suppose from that point of view, from a common sense point of view, 50, 70 years have gone by. Therefore, we should put an end to this kind of thing. And there is no need for any quibbling. There has been a great integration between Jammu and Kashmir and India. And therefore, it's best that although legalistically I believe that it's a right case that the petition should be dismissed, but yet at the same time, if you look at it, the time has come to say that this and this.
So in whatever verdict we get,
enough.
whichever way it goes tomorrow, you will find a lot of subtlety because, ladies and gentlemen, we understand that the Supreme Court has enshrined the basic structure document. Okay, that doesn't mean conversations can't happen over it. They do, should, but there's a basic structure document. So there are 3 points which will be interesting to note the nuance of the furtherance of thought that this constitutional bench will add to the wisdom of so many decades. Number 1, on the basic structure. So you have a reflection on Article 370, which in its part 21, whether it was part of the basic structure or not, we'll get an education or a nuanced understanding of that. You'll get a nuanced understanding on whether the abrogation was desirous of a constitutional amendment or just a presidential order, which is what happened under legal advice. And on the fundamental aspect of this creation which was done of 35A, that when the Parliament moved in to pass a bill, which it passed with I think 127 or some votes in Rajya Sabha, with 300 and something 70 votes in the Lok Sabha, whether the reorganization bill was simply up to Parliament to figure out or not. So there are a lot of nuances will come out from this. So let me get Ajay Kumar back in. So Ajay Kumar, now let me take you, I'm short of time, so let me take you on a different tack, okay? In terms of the furtherance of our understanding of constitutional systems, of the balance between the judiciary and the legislature, what are the nuances that we'll get an additional information on tomorrow? Ajay ji.
I'm not, Rishabh, I didn't get your question, what you are asking for.
Okay, I will try my best to rephrase the question, sir. In terms of the difference between the two realms of governance in this country, the judiciary and the legislature, we'll get a nuanced understanding of the court's furtherance of wisdom on this subject. In terms of whether a constitutional amendment, in which case a constitutional amendment is required, and in which case a presidential order suffices, we'll get a nuanced wisdom, enhanced knowledge tomorrow. What are other areas of nuanced interest which would be of interest, sir?
No, it's very interesting to, as you have raised the debate, that how long India can tolerate this and it can go on. So the first question which will be answered tomorrow, can there be two constitutions in one country, which the people of J&K are asking for in the name of this petition? It will be also answered tomorrow, is sovereignty is equal to autonomy? It is also going to
I think it's the reverse, whether autonomy is equal to sovereignty, but nonetheless.
Yeah, it is also going to answer that with the proclamation of currency and cessation of Government of India Act 1935, the Constitution of J&K, how can have an upper hand over the Constitution of India? They have agreed by signing this that Constitution of India is the sovereign and going to be implemented and accepted in J&K. There can't be two flags in this nation. So far you have denied women the right of equity in the J&K. Do you know J&K resident woman marries a male from outside
Yeah,
J&K?
they lose their property rights. In fact, okay, so I'm out of time, ladies and gentlemen. The reason we are having this conversation, okay, on the eve of this very important verdict, ruling, whatever observation that might come out of the court tomorrow, is because the conversation has to be had in knowing where we are, okay, where we are in the cycle, in the life cycle of this. So as far as the petitioners, we are still in the life cycle of Article 370. It's not a closed chapter, it's an open chapter. The question for everybody else is, do we want it to be a closed chapter one way or the other, okay, with whatever nuanced observation and additional wisdom of precedent setting that we get tomorrow? And do we need to deal with other things so that we don't have to spend the next 50, 70, 80 years still figuring out what Jinnah did in 1952 in the partition that was involved, that resulted in the wars, in the killings, then what Liaquat did, and what Nehru did, and then what grandfather Abdullah did. Okay, so that we can focus on the development of the state, we can focus on POK. It's a worthwhile thought.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.